Another difficulty found in applying this standard consistently is that it is extremely easy for this standard to be applied subjectively. And this is one of the main themes throughout the survival of the fittest article of my paper on the substantially similar standard in evidence law. This slide is about my thesis statement. While substantially similar evidence is usually admissible in court, analyses of substantial similarity are found to be inconsistent across courts. Therefore, the term needs to be specifically defined to create a consistent standard. Substantial similarity is a standard that is inherently subjective and often context dependent. Therefore, there has been quite a bit of inaccuracy and inconsistency of application across courts. This paper will do a deep dive into scholarly articles and research to determine what the standard requires in order to become consistently applied across courts. The contents of this presentation are going to review my article and quote, the main argument of my paper, 3, the gaps in both literature and case law, my findings, my perspective, and the conclusion. The article and quote from research that I chose to add into my paper is this: the substantially similar standard in evidentiary law requires that the prior act or statement offered as evidence must be sufficiently similar to the act or statement at issue in the current case to support the inference that the same person committed both acts or made both statements. The standard is designed to ensure that the prior act or statement is probative of the issue in the current case, rather than being used simply to show that the person has a propensity to engage in certain conduct. This is found in Evidence Law and Practice by Stephen Friedland and Catherine Struve. The importance of this topic is proper application of the standard. What the standard requires, what the standard ensures and its purpose, and what the standard is designed to do. Proper application of the standard applies when someone wants to use evidence of a prior act or statement or product to support an argument in a current case. What the standard requires is that the prior act or statement must be sufficiently similar to the act or statement at issue in the current case to support the inference that the same person committed both acts or made both statements. What it ensures is the purpose of substantially similar standard is to ensure that the prior act or statement is actually relevant to the issue in the current case and not being used simply to show that the person has a propensity to engage in certain conduct. And then the standard is designed to prevent the use of evidence that is more prejudicial than probative, and to ensure that the evidence presented is actually helpful in determining the facts of the current case. My main argument is the main argument of this paper comes from analyzing case law and law articles to determine whether the substantial similarity standard should continue to be used in courts. If the answer to that question is yes, then it must be specifically defined to maintain a consistent standard across courts. The main argument of this paper comes from analyzing case law and law articles to determine whether the substantially similar standard should continue to be used in courts. 3. Gaps in literature. This article, Survival of the Fittest, the origins and evolution of the substantial similarity doctrine. This article discusses some of the gaps within the application of substantial similarity across courts, the evolution of substantial similarity doctrine, how it evolved into copyright law and other areas of law, criticisms of the substantial similarity doctrine, difficulties found in applying the standard consistently, and how this article doesn't keep the standard within evidentiary law. I guess this cut off the rest of that slide. Oops. Go back. Okay. Gaps in the literature. The evolution of the substantial similarity doctrine. It originated in the 19th century. The substantial similarity doctrine had its origins in the 19th century, arising as a way of aiding courts in determining whether accident recreation evidence, either through actual recreation or analysis of other similar accidents, is relevant and admissible. A small but growing number of courts are replacing this useful tool for evaluating evidence with a near blanket rule of exclusion that rejects relevant and reliable evidence. One scholar concludes that the substantial similarity doctrine no longer provides any benefits in a modern trial setting, especially in the context of statistical analysis. Criticisms of the substantial similarity doctrine. Some courts' misunderstanding and misapplication of the doctrine may result from the lack of information and analysis of the substantial similarity doctrine in the academic literature. In most cases, the outcome is consistent with a correct understanding of the substantial similarity doctrine, but the court's application of the doctrine seems to indicate that the proper outcome was obtained by lack or intuition rather than proper legal principles. Although most courts continue to apply the doctrine correctly, the trend toward blanket exclusion is troubling, particularly where the evidence is relevant and reliable. This trend is most pronounced in some cases, such as complex field accident cases, and then difficulties in applying the standard consistently. In each jurisdiction, the doctrine will either 1. Remain a narrow and specific doctrine designed to facilitate courts' screening of other incident evidence, or 2. Expand to exclude all other incident evidence, regardless of the purpose for which it is offered. If the doctrine becomes a blanket rule of exclusion, plaintiffs will find it far more difficult to introduce evidence that shows a history of defective products by certain manufacturers. Defendants will also find it difficult to introduce evidence to show their history of consumer safety enhancements or to defend their design decisions. Plaintiffs and defendants with legitimate claims or defenses will be unable to present them, leading to an increase in both false positive and false negative outcomes. Overall, this article provides a comprehensive overview of the substantial similarity doctrine and its evolution over time, as well as some of the challenges and criticisms associated. 4. The gaps within case law. 2 cases that will be compared and contrasted in this paper are Lovett v. Manchester and United States v. Johnson. Lovett v. Manchester is the substantial similarity standard applied correctly. In this case, trolley wires for the company's double-track trolley line were originally supported by a line of iron poles between the tracks. The pole's presence was not indicated by a barricade or a warning sign, and in this case, the driver claimed he did not see the pole before colliding into it. He and the passengers in his vehicle sued and obtained a judgment against the company, and the company appealed. In affirming, the court ruled that although the center pole was not illegally in the street, so that its mere presence was proof of negligence, the evidence was sufficient to find that the unguarded pole presented a hazard to travelers and that the company was chargeable with the knowledge of that hazard, requiring the exercise of protective action. The city's negligence in creating a hazard from its roadwork did not excuse the company from providing protection. Proof of exact similarities in a case like this, in all respects, is not required, but substantial similarity is sufficient. And this happens where evidence of a similar accident is offered to show a dangerous situation. It is relevant to that issue and therefore admissible if the similarity of the conditions is sufficient to make it of assistance to the jury. In this case, the company appealed and the Supreme Court of New Hampshire affirmed the lower court, and the judgment for the driver and passengers was affirmed. Whereas in United States versus Johnson, the substantial similarity standard was applied incorrectly. In this case, the defendant appealed his conviction of murder in the second degree by the United States District Court, alleging that it improperly admitted other acts of evidence in violation of the federal rules of evidence and improperly calculated the sentencing guidelines. The defendant claimed two errors on appeal. One, that the district court improperly allowed other acts of evidence in violation of the federal rules of evidence, and two, that it improperly applied the sentencing guidelines to a sentence. The court held that the evidence at the time of the charged offense the court held that because the other act was so remote in time and unrelated to the charged offense, the district court erred in admitting the evidence at the time of the charged offense. However, the court held that in light of the substantial evidence of guilt and the limited admission of the evidence, the error was harmless. The court found that the district court had not abused its discretion in disallowing a reduction of defendant's sentence based on defendant's acceptance of responsibility for his actions. The court affirmed the defendant's conviction for second-degree murder, even though the other acts of evidence were improperly admitted. It also affirmed the application of the sentencing guidelines. This is an example where substantial similarity was used in the case and improperly applied and still used to charge the defendant, and they continued to affirm the outcome of the case. My findings on all of this and my perspective. My perspective is that substantial similarity was first derived from a small case in the 19th century to evolving now into an incredibly complicated standard that has been applied inconsistently across courts, but also across different kinds of law. Without a clear declaration of the doctrine, more courts are likely to impose the type of over-inclusive blanket exclusionary rule applied by the Georgia court in Stovall. That in turn will lead to greater numbers of cases where courts will exclude legitimate and relevant evidence. Over time, in conclusion, the substantially similar standard has been taken outside its original scope, applied as a blanket standard across all evidence, must be applied within its original scope in order to be consistent across courts. What I noticed in my research is over time, the substantially similar standard has been taken out far outside its original scope of evidentiary law, where the standard was applied to cases such as screening evidence from accidents involving manufactured products, and therefore has not stayed as a narrow and specific doctrine, but instead has been used by litigators and courts and applied to different areas of law. I personally believe that this standard needs to stay within its original scope in order to be applied correctly across courts. And my restated thesis for my paper is, in order for substantially similar evidence to be specifically defined, the term needs to be specifically defined to create a consistent standard. The standard must be applied, and this standard must be applied within its original scope of tort law doctrine in order to maintain consistency across courts. Thank you. Another difficulty found in applying this standard consistently is that it is extremely easy for this standard to be applied subjectively. And this is one of the main themes throughout the survival of the fittest article.